Hey, everybody, we're going to get started in just a minute.
Don't know that artists that speak about the system, and when they speak about a police state, speaking about how politics engineered the identity of criminality between those from marginalized communities, and when they get the white community to actually embrace it, they allow for state and federal funds to be designated to kind of create a police state around some of these marginalized communities out of fear of criminality. And the song from Dead Prez is the consequence of creating a police state and how we kind of normalize that as a community. Peace.
Peace. We're going to get right into it.
1-5 tonight. Karen Reed's lawyers are accusing Boston's police chief of lying.
And they say they can prove it. This is all about former Boston officer Kelly Dever, who worked for Canton Police when John O'Keefe died. Our Emily Maha is live at BPD headquarters tonight, where those lawyers want an investigation. Emily.
Well, Ed, Erica, Karen Reed's lawyers say Boston Police Commissioner Michael Cox denied knowing that officer was connected to the case. But the commissioner confronted those claims to News Center 5 months ago, at the time saying they were much to do about nothing.
I have no idea what they're talking about with Karen Reed. It had nothing to do with Karen Reed.
That's Boston Police Commissioner Michael Cox responding to questions from News Center 5's David Bienick this past summer.
Did you tell Officer Dever to do the right thing?
I didn't know he was even associated with that case.
Now, Karen Reed's lawyer, Alan Jackson, is calling on Mayor Michelle Wu and the executive director of the Massachusetts Peace Officers Standards and Training Commission to investigate Cox. Jackson says Cox lied, denying knowing and speaking with a former Canton police officer who briefly worked for Boston Police when called to testify during the Reed trial. Reed says that officer changed her story on the stand.
When she was called into the commissioner's office, the story completely changed and it was recanted.
Make no mistake, lead defense counsel in the Karen Reed trial is making a very serious charge against the Boston Police Commissioner.
Retired Massachusetts Judge James Barretto says Reed's lawyer is asking for two different things: adding Commissioner Cox to the Brady list, a list of police officers whose credibility and conduct has been reasonably questioned in the past, and launching an investigation by a statewide police standards commission into Cox's behavior.
Well, the allegations are serious, no question, but like any allegation, they have to be supported by evidence. And they're entitled to due process, which means a hearing, an evidentiary hearing. And again, they must be measured against a certain standard of proof.
Now, we have reached out to Boston Police and the mayor's office for comment, but haven't heard back. I've also reached out to Karen Reed's attorney to see if he submitted his own complaint about Commissioner Cox, but haven't heard back from him either. Live in Boston, Emily Maha, WCVB News Center 5.
So we speak often about the need to kind of unearth or look at your discovery and extract the names of the people involved in the investigation. Because if it's discovered that they're in the middle of controversy or there's a track record of corruption, it's called Brady material, somewhat as you heard counsel represent in the news report. This evidence is vital because it can touch to the credibility of said witness, regardless of how it came out. What's being done in the Karen Reed case is who is now a commissioner making allegations that has been deemed false. Once he is on a Brady list, that means the allegations that put him there will be misleading or falsifying information. When you have him on your case, there's a record now of him falsifying or creating misleading evidence in a criminal proceeding, and that can go to credibility. It happens all the time, but people oftentimes are not aware of the misconduct. So the fact that it's so public, it's so in our face today, just with Channel 5, all the news outlets had it, it creates a very viable, very real example that we've been trying to give. Once you have that evidence, it puts you in a great position to get back in the court. So we want to just kind of show it, to show people that we're not just talking about this. It happens more often than not, but today it's happening with the highest police officer in Suffolk County, which is Michael Cox.
Thank you, Fu. So welcome, everybody. It's Wednesday, October 29th. Welcome to the Harriet Tubman Project's weekly Zoom. I am Jackie, the co-executive director and principal founder Fu Quan, as you all may know. We appreciate you coming back for part 2 of a defendant's blueprint to freedom. As always, we want to open it up and have a discussion. So we'll be sharing information, but we want you to chime in with your questions, make sure that you understand everything that's being shared before we move on to the next slide. The goal of this information is to help you help your loved one get home. So when you work with your loved one behind the wall through the phones, through visiting rooms, through letters, emails, video calls, make sure that you're sharing what you learn and holding them accountable to what they're doing and what they're learning and how they're applying what they're learning. So as I mentioned, part 2, becoming your attorney's co-counsel. And that's a word that Fuquan introduced me to, and we use very often. He is the co-counsel to his attorneys. All right, Fu?
Previously, we spoke about being Harriet. You have to be someone that leads the direction of your case, because if you don't, even though you may have great attorneys, it's a job for them, right? This weekend, they're going to Patriots game. Celtics is on now. They're not spending their life to get yours back. They got kids. They got other responsibilities. They got bills they got to pay. The only one that's committed 100% to get you out is you. Even family, they got other obligations as well. So that's what we touched on last time. So now you, the defendant, you have to be the Harriet. You have to be the principal director, the leader to freedom. You have to go through every piece of paper. You have to go through every avenue. That is you. Co-counsel, meaning your attorneys hired or pro bono. Pro bono is because if you're an indigent defendant, they have to designate you with a counsel, which primarily is based on CPCS, Committee for Public Services, right? You got to have counsel that's designated by the state because you're an indigent defendant. You got to have Sixth Amendment right to an attorney privilege when you are confronted a criminal complaint. So you need a co-counsel. Because there's a first and second chair. The first chair is usually the one speaking all the time. The second chair is the one that sits next to the attorney that takes notes and makes sure that the legal arguments are presented. So we're saying that's you. You have to be vocal, you have to be vigilant, but you have to have the respect of the attorney who understands the jargon initially, the jargon and the literacy that's transpiring in real time. But that's co-counsel, your attorney or the pro bono team that's been given to you either through an Innocence program or just CPCS. Then third is the advocate, liaison outside of prison that can connect you to the world and amplify your voice. That's what a lot of you guys on Zoom are today. You are advocates, right? You got to know how to leverage your platform. You got to know how to connect with the world in ways to amplify the voice of your loved one. That's not an easy thing. None of us are taught that, but it's a skill set that we at Harriet Tubman Project are trying to educate everyone on so that they can help secure the freedom of their loved one.
Thank you, Fu. So I just want to touch base on a few things before we open it up to any questions you have on this slide. We spent a lot of time on the last Zoom speaking about the defendant and their role, the Harriet mindset, to even allow anybody to be added onto your team. So this is what your team looks like. The core of your team is the defendant, you, Harriet, the co-counsel, your attorneys, and then the advocate. So when we talk about the advocate, it may not be a huge role. It could just be the person that you call to say, listen, can you get in touch with this person? I need you to call my attorney. I need you to send an email. Can you reach out to such and such senator? I sent you an email. Can you paste that and mail it for me? So the advocate doesn't always have to be speaking, but they could just help out with some of the logistical things that the incarcerated person doesn't have access to. Can you look something up on the internet for me? Can you read this case to me, this article to me? Can you play this news outlet for me? So you as the advocate, you can play a huge role just by being on the outside and having access to things that your loved one doesn't. And when we speak about attorneys, not everyone can afford to hire an attorney. Yes, when you are in the pretrial phase, you have the right to an attorney, which is pro bono. But after conviction, you don't have a right to an attorney. So you either need to hire an attorney or you need to get someone to take your case for free. And how do you do that? As a staff member of an Innocence project, your job is to apply to as many Innocence programs as possible. Your loved one can make a referral for you, or you need to be applying directly. And we have 3 of them in Massachusetts. CPCS has an Innocence program. That's the program that represented Fuquan. The New England Innocence Project and Boston College has an Innocence program. So in Massachusetts, there's 3. And I always tell people apply to all 3 because all 3 have different funding sources, they have different screening processes, and you may be able to get counsel in one before you get to the other. So don't put all your eggs in one basket. Apply to every Innocence program you have access to. And the 4th one is the New York's Innocence Project. It's just called Innocence Project. And the New York Innocence Project, they cover the majority of the United States. They're a little bit more stricter. They do like DNA stuff, but reach out to all 4 Innocence projects, see if your loved one qualifies for an application. And if so, fill them out and send them back in. And I'm telling you this from experience. I am an intake coordinator at one of these Innocence programs. And I tell people that call in all the time, it may take years before we can screen your case and even decide if we can appoint you counsel or not. So while you're waiting, make sure you're going to the Harriet Tubman Project classes, learning about your case, and applying to other Innocence programs as well. Any questions about your team? Lee, are the public defenders still on strike? Yes, they are.
They're on strike. They really generally deal with people who are incoming to the system. If it's like a glaring felony, like a 265-1 murder, assault or battery with a dangerous weapon with intent to kill, they're gonna give you counsel. But it's only really impacting cases that are weaker in indictments, where there's not gonna be a need to have a security assessment on the defendant. But that's not scheduled to be upended until like the first quarter of next year.
And we have really good questions from JH. What would you tell a defendant who is more focused on raising money to get a paid lawyer instead of working his case? Well, I'll let you answer that question and I'll answer the second one.
I deal with this all the time. Some guys are like, yo, I'm just focused on getting the best lawyer. The problem with that is by the time you get the lawyer, you're not going to know how to navigate with him. You're not going to know the language. That's like spending all your money to get a Lamborghini, but you never took a driving test. So you'll have the Lamborghini, but you can't drive it. You don't know how to maneuver. You don't know how to execute from beginning point to destination. So I'm someone that says you got to do both. It's great to have the resource to get a paid lawyer, but you have to work on your case because you don't know if he's selling you a bill of goods or whether he's a viable advocate unless you truly study the law. You got to be an educated client.
And you don't want to crash that $100,000 Lamborghini.
No.
These attorneys, they cost a lot of money. The retainers are big money. Most of us don't have that type of money sitting around. So imagine using all your time to raise the funds and then putting that funds towards an attorney. You don't know how to direct them. And now nothing's being done still. Now that's just money down the drain that could have been going towards something else. Great question. And part 2 of that question is, do you think paid lawyers are inherently better? I think both of us should answer that. I want to say, just from my experience, when I see people applying to Innocence programs, some of them had paid lawyers and they paid a lot of money for these lawyers and they still lost their case. And what they tell me is, I paid for my lawyer. They never even picked up the phone. I never seen them until we went into court. That's a problem. So just because you're paying for an attorney doesn't mean that they are going to represent you and do the right thing. And majority of the time, it's because you're not leading them. I had a conversation with my brother today, who's going to court on Friday for a serious case. And I had to build with him about his mentality because he's waiting on this attorney to do things for him instead of him leading and being assertive. And he asked me, so what, am I the problem? I'm like, no, you're not the problem. You're the solution. This attorney has so many cases. Paying for another one isn't going to guarantee that it's going to do you any good. You have to take charge, get in that driver's seat, and direct the course of your case. As Fuquan said, these attorneys have other cases, they have other lives. It really starts with you. Do you want to add on to that question?
So in principle, paid attorneys they have their private firms that have their own investigators, they have their own team that can centralize all of their resources around your freedom. That's a great luxury to have, right? But not every paid attorney has those resources. So if you're dealing with a paid attorney that has everything in-house, that can expedite the investigation, that can expedite the process of turning your issues from idea to completion, then it's always great to have a paid attorney because they have everything in house. You're talking about over $250,000, $300,000 though, that you would have to have on deck. You can't just have, because one of the problems with a paid attorney is if you have the funds to get a paid attorney, the courts are not going to grant you the funds to get an expert because you would need to be declared as indigent in order to get an additional expert. So if you do have an attorney, you have paid attorney, you have to make sure that they have all the available things in-house and it's contractually stated that they have to provide those resources to you rather than you just getting the attorney solely and not the very intangible team members that are required in order for you to get your case reversed.
Thank you, Fu. And I have another great question. If you're in the screening process, this is for an innocence program, should you or can you still apply to other programs? This is a great question. I get it all the time at work. The answer is yes. I would rather apply to all 4 innocence programs and then they write back to me and tell me, sorry, I can't take your case. You're being screened by someone else. How would they know that the other program is screening them? Generally, if they work closely together like CPCS and New England Innocence Project, they may reach out and ask, hey, are you screening this person's case? And then we can let them know that we're screening it, but we're not representing them. So that's where the conflict of interest happens. If you are being represented, you have an attorney that's appointed to you, then you cannot get screened anywhere else. No other innocence program is going to screen your case if you are actively represented. But there's that gray area where you're being screened. I'm being screened, but I haven't been accepted. Apply anyways and wait for them to reject your case. But some people are hesitant because they don't know what to do. I say do it anyways and let them reject you after the fact. Just know that your case will be temporarily closed if they find out that you're being screened by multiple innocence programs. But if one program denies you, then you've already put in some headway with the other ones where they'll just reopen your screening wherever you got left off. So please apply to all 4. New York's Innocence Project, New England Innocence Project, CPCS Innocence Program, and Boston College Innocence. Those are the 4 in Massachusetts, or that cover the Massachusetts area. Great questions. Thank you. This is your team. Think about, do you have all 3? Do you need to replace one of these? But at the core, it's you.
Yeah, I got a question about that.
Yep.
So if you do have a paid attorney at one point, right? Like your funds is not funding no more. Like, is there any like motions and stuff you could file for?
Yeah, you can let a judge know your status and you can put an affidavit of indigency. You may have been in a position to have an attorney, but you have to submit an affidavit of indigency. The reason why an affidavit is vital is because you're saying it under oath that you don't have funds. But if they find out you do, they won't generally allow you any access to funds. But you can put in a general access to funding through an affidavit of indigency, and that should clear you. But you have to have the viable means to be able to dictate that you're indigent, which is like under 18,000 a year. Indigency, that's how it's defined.
That was gonna be my next question.
You said under 18,000?
Something, yeah.
True. I'm indigent and I make more than that. Good question, Joey. Thank you. Another question, if I want to stand as an advocate for my loved ones, how do I start? I think that's a question a lot of folks have. And just being on this Zoom today is a start. Getting some information, tapping in with other advocates. One class that I'm going to have, a workshop that I'll have on Zoom when we return from our 2-week break is literally the Advocacy 101. You want to have your loved one's bio. This is something we talk about a lot. What is your loved one's biography? Before they were incarcerated, how were they wrongfully incarcerated, and what are they doing now? So start off with their bio, get that from them, edit it with them, and make sure that there's nothing in that bio that is going to hurt them legally. So you may want to create the bio, share it with their attorney, make sure that it's okay to be shared publicly. And that will be the start, because that will be the foundation to build out social media campaigns, petitions, or just sharing their story with legislators and other folks in the community. So to answer that question, start the bio and continue to tap into these Zoom meetings, because I'll break it down step by step. And in the process of creating your bio, one thing that Fu did that was extremely helpful for me, he went through his archive of every program he's took, every accomplishment he's had. So I had so much content from him before I started the Free Fuquan campaign on his Instagram, because he gave me his bio written out and material. So ask your loved one for copies, pictures, flyers of things that they've been involved in. I think you sent me like your D report, programs in the DOC that you completed. What are some things that you sent me outside of that?
I mean, you got to be transparent. So you got to send the good and the bad. As much as you want to just send all the programs and I accomplished the RA, you want to put the tickets too, because that's the first thing that the media is going to pick on. That's the first thing the prosecutor is going to pick on. So any available thing that you know that is real, you have to send your loved ones. One thing that I strive to do is making sure, if I have her advocating for me in society, I want to make sure she's not blindsided by anything. Because, yeah, he did programs, he did CRA, but then someone could say, you know, he did 5 years DDU because of a stabbing. That's something that you want to inform your loved ones so that they can pretty much frame your narrative that you elevated from it. Regardless of what it is, you got them to get them the good and the bad. Make sure you have an elevator pitch around it, but you have to make sure you give them every viable thing that they can actually speak to in a positive way and help them combat some of the landmines with the negative stuff.
Thank you. I wasn't even thinking of that, and that's something. And food didn't stab nobody. That was just an example. But it's a real thing for people, whether it's self-defense, whatever the story is behind that. You do not want to be blindsided. Appreciate him for being transparent about his entire journey, 28 years and before he got incarcerated, because that helped out tremendously. I would also say their criminal record. So if they have a criminal record outside of this current incarceration, you should be well aware of what that is and, how they came about, accruing that. Great questions. Thank you so much. So now we're going to move into the next section. First section was your team. Now it's the tools and materials that you need to freedom. And I'm going to pass it back to Fu.
Yeah, so the beauty that, guys have now, they have a tablet, right? We used to have to go to the law library to get access to the computer. I know a few years ago, the Max put it in the actual unit, which was favorable because there was issues going on with access to the library. But now having a law library on a tablet is transformative. The beauty about the tablet is it has no restrictions. So at 2, 3, 4 in the morning, I'm on the tablet studying law. As long as you get Wi-Fi, it's on, right? When I was there, a lot of guys wasn't really using it. They always told me they'll get to it, but having a tablet that's updated every day, if there was a new case that came out today, that tablet will have it. That's a game changer. So it's learning how to be resourceful with that tablet. The next thing is the typewriter. I never wrote out my arguments with handwritten letters to my attorney because a word can get misconstrued, a number can get misinterpreted. I typed up everything, right? So typewriter is probably one of the most expensive things that one pays for, and it costs now more than a TV, right? But if you want to keep professional records, you have to get a typewriter. It's an investment. It pays for itself in the long run. But you want to make sure when you type something, you get copies of it, but you want to make sure it's professional so your words aren't misconstrued, because not everybody's handwriting can be interpreted, right? Finances and stamps. A lot of people don't understand legal work costs money because you have to send it out. And if you got a lot of paperwork, you're going to probably need 20 to 30 stamps to put on a package, right? You may have to put it through certified mail. You may have to take the money out your account because you may not have stamps to send out packages. But if you're sending out this work that you're typing up and you're accumulating, you need stamps. You need to budget your legal. I know a lot of guys doing legal work, then they asking me for stamps to send out their legal work. Like, you have to budget that. Especially guys going to canteen every week, buying everything but stamps, right? So you need to have stamps. Also, access to the law library. Access to the law library, even though there's tablets, the law library does have things that are not in your cell. You should not have a copy machine in your cell. So the library has that. You don't want to send out any document unless you copied it. The law library has that. The law library also has access to your docket entries. Anytime I went to court and I wanted to see how it was reflected in the docket, I went right to the library and the librarian printed out to me the docket, right? So you want to have access to your docket entries. That tells the procedural history of your case. So those are the general tools you need, to kind of equip yourself with combating everything and making sure you maintain a level of professionalism.
I have a question. When we talk about finances and stamps, what are some legal ways for people to make money behind the wall?
Well, the way that I did was I had a store. People that know me on the inside for years, I sold sodas, right? I bought $40, $80 worth of sodas, and that's how I started. And that gave me access to stamps, so I wouldn't have to ask no one for money. Rarely did I ask anybody for money. And I got my mother and my sister on here, so they know I'm telling the truth. I don't ask for money because with a store, they know you have a store, you got access food in your cell, but they're focused on drugs, they're focused on homebrew, they're focused on knives and weapons. They know who's who. If you keep it respectful, you keep it transparent, you don't have a lot of stamps in your cell, they pretty much let you run a store. But you can also take industry money, save half of it for stamps, or making sure you got a budget for legal work, and you can save the other half for food. I know it's difficult because the prices got inflated and they never truly advanced the pay grade of those who work, but you have to figure out a way to make it work. But I generally use the store, whether it was food, commissary products through a store, or just sodas. Some guys got ice cream, some guys sell chicken. And as long as you're not disrespectful to staff, rarely does someone get locked up based on excess food in the cell and running a store in a unit. Because every unit has about 4 or 5 stores and an average unit of 68 people.
Thank you, Fu. And I can attest to that. He never asked me for no money. He always took care of everything financially. And I was very appreciative of his way of making money legitimately. I've seen other guys create artwork, legal works. Fu never charged for legal work, but some people do legal work and they charge for it.
Yeah, some guys make food
Cooks.
every week. Some guys bought property in their own country, like Dominican Republic, by selling chicken sandwiches every week. Like, there's ways to really get to it without jeopardizing your freedom through selling drugs, making homebrew. Like, guys legitimately make money just selling food.
So now that we've talked about the tools that you need behind the wall to be successful in engineering your freedom, Fu's going to break down the actual materials that is the core of all of this.
So this is something that I wish I had someone put me on to for the first 24 years of my incarceration. So I was fighting my case with just the mere transcripts I had and the facts that we accumulated when I got convicted. But what got me out is what I'm about to tell you. 2021, I realized that I didn't have access to my whole file, right? So the first file that you need is your trial attorney's file. Not just the transcripts, but his notes. This is pre-trial. Every time he interviewed you, you should have those writings. You should have your letters that you sent him. You should have interactions between him and the experts, emails between them and the prosecutor. That's stuff that a lot of us never seen, but we're entitled to have whenever that attorney is relinquished from our case, right? You need that first. That's the primary thing you need. Like I said, that is not just trial transcripts or motions you put in pre-trial. That's his personal notes, his trial strategy notes, his contact with the district attorney, his contact with experts, his contact with you. That's very extensive. And there may have been things that your attorney hid from you that you never knew he was in a possession of. But the only way you can see that is you had access to his file. The second thing is the police file, right? The police file, the police is the most important file because they're the ones on the ground who created your case. They're the ones walking around with a notepad, speaking to witnesses, interviewing witnesses before the Commonwealth tries a case. The police are the ones who can create the evidence that a prosecutor prosecutes in court. That is the hardest file to get, a police file. The mayor of the city of Boston can't even get access to that file unless it's given to her through a court order, right? But that is the hardest file to get. The third file is a DA file. Now, the prosecutor retrieved the evidence from the police. Then they had their own investigators. They had their own experts. They had their own team do a thorough analysis of that evidence, and they created their own file as a result of that, right? Now, in order to get access to this file when you're convicted, you have to have an inclination that something happened within your trial that wasn't fully exposed to you. Now, it's a hunch, it may be a gut, but once you ask the judge, is there any way that the judge can look at certain pieces of evidence that you never had access to? The judge can do it. Now, if the judge looks at it and see that there was something material toward your defense and they hand it over to you, then that can create a ground for the district attorney to hand you everything that was in the possession of that line. Sean Lee's case, there was an incident that happened to show that the police department, the state police, was contaminating with his evidence. Once the judge was given that narrative, he allowed access to everything in his file, right? And that created the opening of what he has now in a new trial. So the DA's file will be given to you if you're able to show the court that there's something exculpatory never given to you. But the DAs also can be politically correct and create what's called an open file, where they give you access to your file after you exhausted all your appellate avenues. That's what Rachel Rollins did in Suffolk County, where a lot of us got access to our file the first time because she made it part of her political campaign to have open file policy, right? Most DAs don't do that now, but that is an avenue. If they trying to do the right thing, that's something that Harriet Tubman Project is going to be pushing all district attorneys. But these are materials that you need to have if you're going to combat your case, because you never know what's in your file until you have access to your file. And then your file is going to give you a narrative of what exactly happened in your case. Because it's one thing to govern off hunch, but if it's not on the record, there is no way a judge is going to reverse your conviction. So these are the three most important things you need in order for you to begin the fight of your freedom. Most of us, even me, went through 24 years of fighting without any of the three. But in the last 4 years, getting those three helped me reverse my conviction. That's how big it is. That's how magnified it is. And anyone that's been a part of Harriet Tubman Project knows that those are the first three things you need in order to effectively fight your case.
Thank you, Fu. These Zoom meetings are recorded. I know it's a lot of information. I want you to take notes, ask questions, but then we'll also be sharing the video link so that you can rewatch it and get the nuggets that you may have missed. A few questions. How can you get access to police files, public records requests? And that's a training that we'll do in one of these upcoming workshops to show you how to put a public records request in. The defendant can do it from prison, and so can us, the loved ones, put in a public records request with the police department. So as long as you know what police department it was in. What's the other way?
The other way to get in your file is once you're able to get the DA's file and show that there's some missing pages or missing evidence, you can ask the judge to say, listen, the only ones who have this are the keeper of the files in the police department, and we want to see that whole file. But you would have to see some lapses that are visible in the DA's file. That's exactly how I got my police file. Like, let's say, for instance, they give you page 1, 2, 3, 5, 6, 7. If you can show them they didn't give you page 4, that can create grounds for you to get the whole police file. And generally, the DA will agree if they say they don't have that evidence. They will agree with you as the defendant to get access to the police file. And court orders are mandated. So if a cop or a police department doesn't comply with that mandate, you may likely get your case dismissed. That's how strong it is when a court orders a police department to turn over evidence. If they don't, they're found to be in contempt, and a defendant can benefit off that and have his indictment dismissed.
That's huge. Is the judge who looks at it, the DA files, the same judge that you had at trial, or do you get someone else?
You get someone else. For me, I was convicted 27 years ago. So the judge now wasn't on my trial.
We'll get that to the next slide, actually. Great question. And then quick answer to this one before we go forward. If someone is falling into selling drugs to pay for a lawyer, is there another way of talking him out of it?
It depends on who the person is. Some people limit their hustle. Some people feel like that's the best avenue for them. But I've been through that 1,000 times. It's difficult. As much as you think you got to people, some people are addicted to hustling. That's a real addiction, right? Particularly when they feel like it's easy access to capital. But I try to give them the worst case scenarios, let them know that they put themselves further and further in the hole, which prevents them from the tools that we spoke of. But it's all based on an individual thing. There's no general answer for that.
So from my perspective of what I've learned from Food's journey is showing them other ways to make money. It may not be fast, but they're still making money legitimately. And they have to understand that if they get caught, that's going to make it harder for an attorney to really deal with them. And it's going to make it harder for them when it does come time for them to be released on parole or stay of execution. Because if you're pushing for a parole, they're going to bring up the fact that you were selling drugs in prison. That's going to hurt you at parole, even if you did everything else. Or if you're asking for a stay of execution, like the way Fu came home, one of the biggest merits is, are you likely to reoffend? And selling drugs will send you right back to prison. So if they bring up, the prosecutor especially will bring up that you were selling drugs in prison, that could potentially hurt in the long term of you coming home. So they have to look at the long term of this fight instead of just looking at what's going to satisfy right now, today. But it's all part of your character. How you're doing your time is a huge part of your character. Great questions. Avenues of innocence. So now that you have your team, you have your tools and material, what are the avenues of innocence that you should be pursuing in Massachusetts as a post conviction, after you've been convicted?
So real briefly, the first thing that you have is a direct appeal. If you was sentenced to a second degree and under, you don't go straight to the highest court. You go to the Mass Appeals Court, right? That hears your arguments to see if you have any merit, but it's based on issues that are on the record. They don't deal with newly discovered evidence or newly available evidence. But the highest court of the state, the SJC, anyone convicted of first degree murder, they go straight to the highest court to examine. And it's a problem because a lot of people go to the SJC before they flesh out their evidence. The problem with going to the highest court first is once they make a decision and it's not in your favor, your case is final. So your case isn't final when you get convicted. Your case is final when the highest court deems it affirmed. And if new law comes, you're not able to get access to it. Like, there's a lot of limitations to it. And when you go to the highest court, you want to make sure you got your greatest arguments. So direct appeal initially isn't the route that I would go until you flesh out all your issues with a Rule 30 or a motion for a new trial that we'll discuss briefly.
Thank you, Fu. So I think the biggest thing about this is no newly discovered evidence is going to be presented at the direct appeal. They're just challenging the conviction to see if everything was done properly. And everyone has the right to a direct appeal as long as you went to trial. If you had a plea, you don't get a direct appeal.
Rule 30, the strongest, most credible instrument we have in this state, because Rule 30 is basically saying a judge can grant a new trial if you uncover newly discovered evidence or newly available evidence, meaning evidence that the jury did not hear. And the evidence doesn't have to say you will be exonerated. It just was the justice was not done because a fair and impartial jury never heard that evidence, right? Which is a minimal standard, but Rule 30 is the main reason why most of the guys that get released get out. All these guys that you see released got out because of a Rule 30, which is a motion for a new trial, newly discovered evidence. This is the main route that we use to expand our issues before we go to a direct appeal. A lot of lawyers that come on to your case initially are not hired for you to deal with a Rule 30. They go straight to a direct appeal. But you have to be convincing as a Harriet to shift their priorities to say, no, we need to expand the record. We need to get access to these files so that we can create an argument that strengthens our narrative to present to the highest court. But Rule 30 is the most viable avenue that get people out in the modern day, particularly when you're dealing with when you wasn't given exculpatory evidence or newly available evidence.
So if y'all aren't familiar with Fuquan's case, like he mentioned, he got the open file discovery from Rachel Rollins, which gave him 10,000 pages of newly discovered evidence. He put in for Rule 30. What was it? This Monday, the judge and the prosecutor agreed that he should get a new trial, which is what the Rule 30 is, motion for a new trial. And they agreed to that. So that opens up an opportunity for people to come home on a stay. It opens up exoneration and so many other things. So focus on that.
So sentence appeal. When you get convicted, there's a separate process, a sentence appeal, where the judge goes through the facts of the case. You may hear from the victim's family. Then they render a decision regarding your sentence. They're not focused on guilt. They're focused on sentence. Now, you may not agree. When you give in capital cases, they're going to give you the number that's in the books. Life, 25 to life, 30 to life, right? But when you're convicted of a manslaughter, where you're able to get a 10 to 12 or 18 to 20, vehicular homicide, other cases that are not first and second degree, what you generally put in is a sentence appeal, because you're saying that although I waived my right to a jury, I was over sentenced. But you have to make that argument by stating that there's new evidence, there was evidence that wasn't factored in the jury's decision, or there may be evidence of credibility that I wasn't never able to introduce that may have factored in to giving me a more lenient sentence. So as soon as you can get convicted, if you feel that way, you got to put in a sentence appeal, which is Rule 29. But it can only be done when someone has formally endured a plea agreement. You don't generally put this in with a general finding of guilty, particularly around first and second. You do this around anything under than a second degree murder offense. You can put in a sentence appeal if you're contesting the sentence that was hammered down from a judge whenever your trial was finished.
So, Fu, correct me if I'm wrong, when you were resentenced last year because of the Mattis law, that's a sentence appeal?
No, it's a Rule 30A. Rule 30B is motion for a new trial. A Rule 30A is a legal sentence. So when you hear about Mattis defendants, right, and we celebrate it because guys are coming home, what that really means is these guys, we were sentenced unconstitutionally. We was given unconstitutional sentences because the facts dictate that we all could have been rehabilitated, right? So that's considered an illegal sentence. That's more egregious than a sentence appeal where you're asking from the mercy of the court to a sentence that's been rendered. A Rule 31, which was under Mattis, a Rule 30A says we was all given illegal sentences. And that's the reason why they immediately got guys a parole and guys are home, but they're two different functions.
Thank you. So if your loved one's over sentenced, looked into these avenues. My loved one just received a life sentence and his appeal lawyer is already dealing with the SJC for the direct appeal. Do you recommend trying to talk to the appeals lawyer out of doing that?
I do, because what your loved one has to say is, listen, we need to see my lawyer's file. That may uncover some ineffective issues that we may need to present in a Rule 30, because direct appeals do not like hearing ineffective claims that wasn't outlined to the trial judge. You have to try to get a stay of your direct appeal or tell them to suspend it so that you can explore potential arguments in your Rule 30, because a Rule 30 helps expand your issues. If they go right now without the issues expanded, they may go to the direct appeal with 1 or 2 issues. But if you go to your Rule 30, that may open it up to 5 issues to elevate your chances of success when you go to a Rule 30. No, through a direct appeal.
And again, this is a lot of information. So when we drop the link to the YouTube video with today's recording, spend some time on those free phone calls listening to this Zoom with your loved one on the phone so you guys can break down this information and make sure that you connect the gaps. DR said, is there any literature that best helps people understand the law?
So for me, I'm so used to having prison material, but I'm up at night researching YouTube. I've seen different rappers quoting legal. There's a lot of creative things there, right? So I'm gonna eventually start putting some things out there that the loved ones, in addition to those incarcerated, have access to.
Thank you. I am going to drop the link to our YouTube page. And if you press subscribe, then when we upload today's Zoom meeting, you'll get a notification on your phone about that. Usually we do that within a week. We're going to be taking a small break, so there's no Zoom meeting for the next 2 Wednesdays. We'll resume on November 19th. In the meantime, all of these Zoom meetings that we've been recording for over a year now, we're going to continue to put content out on the social media pages, on the YouTube. So continue to study that, continue to share with your loved one, call in with your loved one, listen, break it down, and put a game plan together. These are the blueprints to freedom. And Fu did it. I know a lot of people were probably questioning, if he's so smart and he knows the law, why is he still in there? Well, he's home now. And like he said, he spent 28 years, but it wasn't until the last 4 that really dictated his freedom. So Hamza, do you want to just speak on the bill real quick? I have the flyer up here with the little information. If you're on your phone, please screenshot it so that you have everything.
Yeah, no, thank you, Peace. Also, thank you, Fu and Jackie, for like creating spaces like this and just teaching like the legal processes that goes on that may be difficult to just navigate. But yeah, I'm on my phone. I'm like actually traveling, but I just obviously tomorrow is gonna if everybody's gonna be there, then I could just do another present like just present the bill. But essentially, if you're not gonna be there, I'm working on a bill trying to end lifetime parole for emerging adults and juveniles in the state of Massachusetts. So like we would love for like people to like support the bill, but also like when we plan to get the hearing, which should be I actually just got some good information that we should be hearing the hearing date in the State House mid-November. I don't know exact date, but once I have it, what I'll do is communicate it to the Harriet Tubman Project and hopefully we could pass it out to everybody. But essentially what we're trying to do is have a collective action, well, a virtual community collective action. And what it is that we're gonna all draft our own written testimonies together. I already had drafted up the template. So if there's confusion of like how to write a written testimony on a bill or anything like that, I already have that drafted up. So all you have to do is just kind of basically fill in the blanks, but we're also going to have folks there that can actually speak to like maybe some concerns that you may have or some suggestions or questions, and we're going to have some answers for you. And then once we draft up our written testimonies, we're going to have the link that we're all collectively are going to submit our written testimonies for the bill. And then if you choose to like want to testify either virtually or in person, we're going to have the registration link as well, so you can do that as well. And like again, this is a collective action that we're trying to do. So once I have the hearing date, I'll give everybody the information so you can participate in it as well.
Thank you, Hamza. And I just want to add some context to this end lifetime parole for juveniles and emerging adults. The law has changed where folks, as Fu mentioned, were unconstitutionally sentenced to life without parole if they were under the age of 21. A lot of people are coming home, but they're coming home to lifetime parole. So for the rest of their life, the rest of their natural life, they're on parole. So if they catch a case, if they get pulled over, if there's any interaction with the law, they have the potential to go back to prison. So that's like thank you, but no thank you. They're letting people out, but they're waiting for them to mess up. And we all know, or we should know, how structural racism works, where there's things put in place that are waiting for you to break the law. And if you don't know the law, you're more likely to break it. So this bill is extremely important because if you don't get exonerated, you're most likely on lifetime parole as a juvenile or emerging adult. So definitely let's, support Hamza, Alameen, and everybody, TPP, that is working on changing the law, because that's not right. They paid their dues, they did their time, they should be free. Parole is not true freedom. And as we mentioned, and as you know, we have a huge event tomorrow at Northeastern. If you can't make it in person, there is a Zoom link. It's our first event since Food's been home. It's our first event in Boston. We have a panel. We have people calling in from prison. We have artwork from people that are incarcerated. We have performances from people that are incarcerated. And you'll hear from advocates, loved ones, formerly incarcerated people. And it's just going to be, an educational, communal event. And we want to see you there, either virtually or in person. I'm just going to open it up for any other questions before we log off. Any other announcements? For those people that are on the Zoom, they deserve to know what happened in court.
Oh, so what happened in court was the judge formally dismissed and vacated my conviction. I'm no longer convicted of murder as of Monday. Now, the prosecutor, tomorrow or Friday, they're going to put in a notice for my case to be absolved, innocent. So it creates my first step of exoneration recognized by the state after 28 years. So everything's in place. Either tomorrow or Friday, they'll put it in writing. But, my exoneration is complete. I'm 99% there. It's just one more area. So a long fight, a lot of work. A lot of people think I did this just to get out of prison, not knowing I'm out of prison and I'm going even harder with balance, right? But it's a long fight. I learned a lot. I feel like it's my responsibility to pay it forward. But yes, I'm 99% exonerated as of now.
Thank you, Fu. So I'm just going to close it out as we usually do, just making sure we see the faces and the names of those that we're still fighting for. These are the free, but still frightened. We appreciate you all for joining us on the Zoom. It's going to take a community to really shout out to Joey. He's on here today.
Joey eating over there. Want to know what he's eating?
Hamza, shout out to you, doing incredible things. I finally updated your photo. No more jail picture. And Fu, shout out to you. I updated your picture. No more jail picture.
No more jail.
But yeah, we still fighting. We do this because none of us are free until we're all free. And there's a lot of brothers that are behind the wall that are counting on us. Johnson's artwork is going to be up there tomorrow. Come check it out. And we really want to, bring more people home, just like Harriet did. If there's anyone that's calling in from behind the wall, feel free to unmute yourself. Yeah, peace. Thank you, Fu.
Shout out to my guys on the other side. We didn't forget about you. It's only going to be more amplified. Appreciate y'all.
Hello. Oh, I just want to say congratulations, bro. I was really wondering what happened because for some reason they wouldn't let her tap in, so we didn't know. And around here you hear a million stories, man. But congratulations, man. I love to hear it. Congratulations.
Nah, I appreciate you, bro. I was in Stacy Borden's house yesterday, and we was building about you, and we're definitely gonna get up sometime next week, figure out a strategy, man, to help get you out. So, I'm just on the ground, and my word is always bond, but I'm doing it as a free man. So I always appreciate your love and your consistency, and just know it's not lost.
Alrighty, man. Congratulations, man. Please let everybody I know, you know what I mean? Pass
You
my
have
love
1 minute left.
And I thank you for me and for all the brothers in here, man. And you too, Jackie. We appreciate y'all. We love y'all, man. Thank y'all.
Peace, bro.
Peace. And thank you for everybody who it's their first time or they came back from last week. We appreciate you. We're trying to grow this community, and soon we'll be meeting more in person to continue these conversations and workshops. Thank you, everybody.